we risk undermining the very foundation of our professional credibility. We must remember that our allegiance is first and foremost to the Constitution and this Republic, not to transient political interests. Over 3 decades have passed since the adoption of our Constitution. During this period, our Republic has tested and continues to test the resilience of its democratic institutions. In doing this, the bar has played a crucial role in assisting the Supreme Court to interpret and enforce the Constitution. But outside the courtroom, the advocacy of the bar as a professional group has lacked consistency, bringing into question its adherence to principle. Ladies and gentlemen, when in 2015, an Article 146 petition was received by the Chief Justice in relation to the former chairperson of the Commission on Human Rights and Administrative Justice, Madame Loretta Lamte, the bar failed to speak out about process. In the run-up to the 2016 elections, the then opposition New Patriotic Party engaged the Electoral Commission in court battles over the voter identification system. This gave rise to the Abu Ramadan line of cases. Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Araba-Tokono. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The 3 petitions aforementioned touch and concern office holders of 3 constitutional bodies critical to the sustenance of our democracy. The independence of the 3 institutions has been guaranteed by the Constitution. The 3 occupants were all women of significant repute and members of our noble profession. The 3 committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the 3rd petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen. The Ghana Bar Association is not merely a professional body. It is a moral compass of the legal fraternity and a key pillar in the construction of our constitutional democracy. As Lord Denning once wrote, and I quote, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased." The same applies to the bar. Our authority as a profession depends on public confidence that we stand above the fray of narrow partisanship. Let us therefore be the conscience of the Republic, fearless when governments overreach, impartial when opposition agitates, and always faithful to the sovereignty of the people under the Constitution. And talking of sovereignty, we should desist from the temptation of inviting foreign interference in our internal constitutional processes. As a professional body, there is absolutely nothing wrong with forming relationships with like-minded foreign associations. Such relationships are necessary for cross-fertilization of ideas on professional matters such as standards. That is where it should end. Interference in constitutional politics risk violating the principle that sovereignty resides in the people of Ghana, in whose name and for whose benefit the powers of government are to be exercised. My distinguished colleagues, the task before us is clear. We must renew the spirit of the profession. We must strengthen ethical discipline within our ranks. A few errant lawyers can tarnish the credibility of the entire bar. The Ghana Bar Association must be vigilant in holding us to the highest standards of integrity. We must deepen access to justice. Legal aid must not be a token gesture. It must be a living reality for the poor. The state is committed to resourcing the Legal Aid Commission, but the bar must also embrace pro bono culture as part of its civic duty. We must modernize our justice system. E-filing, case management reforms, and digital court process, records are not luxuries. They are necessities if we have to build a judiciary fit for the 21st century. We must reclaim our role as guardians of democracy. The voices of lawyers must not fall silent when constitutionalism is under threat, whether from the executive, the legislature, from political parties, or even from within us. Madam President, my lords and learned friends, the quasi-constitutional nature of the bar places it squarely in the center of our state bureaucracy, and by extension, our politics. This deprives the bar of the requisite independence to be truly professional. This constitutional grant of privilege, or if you wish, of right, flies directly in the face of the equality of treatment that ought to be accorded to all professional bodies in the country, in terms of Article 17 of the Constitution. Of course, the Constitution was written by and for lawyers. However, and excuse my language, this self-serving ingratiation of the bar into the bureaucratic structures of the state flouts the principle of equality. So, Madam President, I'm inviting you today for us to re-examine critically this model of the relationship between the bar and the state that puts it at the center of bureaucratic politics as well as the politics of the country. The destiny of Ghana is tied to the integrity of a legal profession. If we stand firm, this republic will stand firm. If we falter, this republic will stumble. Let us therefore recommit ourselves to the ideals of our forebears: justice, integrity, freedom, and service. And let the bar of Ghana remain, as it has always been, the living conscience of the nation.